This week we learned a Harris County Justice of the Peace, in a genuinely unprecedented move, invalidated thousands of criminal warrants claiming he was abiding by the Constitution. While the criminal case is kicked to the legal curb by Precinct 1 Judge Steve Double, are low-level Class C offenses like traffic violations and the writing of hot checks. The Harris County DA's office called this free pass for thousands of criminal suspects a decision that could, quote, endanger the lives of citizens and law enforcement officers. Panel, Double is an outspoken advocate for criminal justice reform and appears to be pushing the legal envelope here to see where the chips fall. So you've looked at this. Thoughts?
Well, first I thought the way that he did it, of course, would irritate a lot of people, because on his own he went out without letting people know he was going to do this. So that would make a lot against him. But the way I read it was, he's saying, why are we sending the warrants? They're non-jailable offenses. They're misdemeanors. If we bring them back in, we can't assess a higher fee on them. So why are we spending all this money sending officers out serving warrants when they could be doing something else? Because when they do find them, there's nothing really that happens to them that even makes them have to come back and do pay their fine or what they had the warrant out for.
Okay, I'm not the sharpest knife in the box, but why even have the tickets at all if we're not going to hold anybody accountable for them, Michelle?
Well, that's an excellent question. And Class C misdemeanors, like Sue said, are non-jailable offenses. They're fine-only offenses. So being able to arrest an individual on a Class C misdemeanor is absurd. With that said, he is a judge. He is legislating his own beliefs from the bench. But I think that what Judge Double needs to do is he needs to go run for Texas State Senate or Texas State in the Texas State House and do something and make a piece of legislation to where there are no arrest warrants for Class C misdemeanors. But legislating from the bench is not the way to go.
Charles, jump in here.
No, I'm actually really glad she said that, because that's not, I didn't think of it that way before, because I do think that for these Class C misdemeanors, these are things that don't carry a sentence of jail time, and so why are we using police resources on it? But you're right, I mean, he is not a legislator. He should be following the law, and so not trying to bend the law to his own will and for judicial advocacy, although I do agree that we should be moving towards not arresting for non-jailable offenses. Okay, pragmatist, Bill King.
Look, I think that he raises some good points in the letter. I mean, this system is broken. We need to think about how to fix it. The problem I've got is the judicial activism piece of this. Look, a judge, what he did was called sua sponte. He acted on his own without a motion from the party. What a judge is supposed to do is sit there and get motions from the party and rule on those. He decided on his own to go out in thousands of cases, which he has no idea what the circumstances of those individual cases are, and cancel warrants. And I don't think he's got the power to do that.
10 seconds, I'm sorry.
The system's broken. Needs to be fixed.
Amen.
All right, we're leaving it there. When we come back, astonishing revelations in the long-awaited murder trial of a cop gone bad, and the very